Chapter 10, Miscellaneous Credit Guarantees, Sec. 151. In general, we have already considered certain credit guarantees, which may be required in connection with litigation, and have discussed the underwriting of bonds of that character. Those are, however, not the only credit guarantees which surety companies may be asked to issue. Application is often made for bonds which, though not needed in connection with litigation, directly guarantee the payment of money, as for example, where it is desired to guarantee that one of two joint makers of a promissory note will pay it and thereby exonerate the other. In most cases, however, the guarantee is not absolute but depends upon a contingency which may or may not happen. Credit guarantees are often presented in the guise of contracts or mere honesty risks, so that it is often necessary to look carefully for the danger signal of credit guarantee. Any proposition that is not clearly within the scope of one of the foregoing recognized classes of bonds should be carefully examined to see whether or not the bond will directly or indirectly guarantee that the principal will pay a sum of money, either absolutely or upon a contingency. If so, the bond should be rated as a credit guarantee. In underwriting bonds of this kind, the same general principles will apply as in the case of judicial credit guarantees, and reference is made to the appropriate sections. For convenience, these principles may be summarized as follows. 1. A surety company cannot afford, for the small premium received, to gamble on the chance that the contingency upon which the liability depends will not happen. There is a reasonable chance that it will happen, or the bond would not be required, and the underwriter must assume it will happen. 2. Collateral security in the shape of cash or its equivalent in marketable securities to an amount equal to the greatest possible liability, generally the amount of the bond, should be required. 3. Collateral should not be waived unless the applicant is a partnership or corporation, which does not depend for its success upon any one man and which has a well-established non-speculative business of at least 10 years standing, unless the concern is rated by the mercantile agencies at 15 times the amount of the bond with the highest grade of credit and the financial statement is verified to a reasonable extent, and unless the applicant has a first-class reputation in every respect. 4. Collateral should never be waived on the strength of outside personal indemnity, no matter how strong the indemnitors may be. Experience shows that even if they are solvent when liability accrues, they are likely to be slow in meeting the obligation, so that the surety company will be required to put up the money and await the pleasure of the indemnitors in making reimbursement, or perhaps will have to sue the indemnitors. That subjects the surety to many chances of loss, and in any event, makes the business unprofitable. 5. The more distant the maturity of the obligation, the greater the chance that the financial condition of the principal will change, and therefore the greater the chance of loss if the bond should be written without collateral. In the succeeding paragraphs, some of the more important miscellaneous credit guarantees will be considered, and they will show the application of the foregoing rules or principles. Sec. 152. Bond to discharge a mechanic's lien. We have seen that in many states a man who has done work or furnished material for a building may, by filing a statement of his claim on the office of a clerk of court, or other public office, obtain a lien on the building and the land upon which it stands, for the amount due. The law generally provides that such a lien may be discharged, and the property freed therefrom, by the giving of a bond conditioned in effect to pay the claim if it be found to constitute a valid lien. Liens of this kind are most often filed for labor and materials furnished to a contractor, and when so filed, the owner, as he has a right to do, generally declines to make further payments until his property is freed from one lien. Contractors, desiring that the regular payments under the contract shall continue, are the most frequent applicants for bonds of this kind. Such a bond is of course a credit guarantee in that it guarantees the payment of money, and, while the guarantee does not become operative unless the claim is held to be a valid lien, yet a surety underwriter must assume the claim is valid. The liability can safely be estimated at nothing less than the full amount of the claim, with interest and such costs, counsel fees and expenses as will probably be necessary to establish the claim as a lien, and as an underwriting proposition, it is a rule of almost universal application that collateral security to that amount should be required. These propositions are essentially bad because, 1. While a contractor may have a good record and may be in good standing, the very fact that he has permitted a lien to be filed against him is evidence that he is in financial difficulties or that he is overtrading. The filing of the lien should operate as a warning to the surety company to tighten up on the issuance of contract bonds rather than as a license to issue hazardous credit guarantees without collateral. 2. The business of a contractor is essentially speculative, so that contractors are not of the class for whom credit guarantees can safely be executed without collateral. In practice, however, strong arguments for the issuance of these bonds without collateral are often brought to bear upon an underwriter, as for example. 1. The applicant, a contractor, may be a regular client of the company and in the habit of getting what he wants in the way of contract bonds, and may expect the company to issue this bond without collateral, so that to require collateral may mean the loss of all the contractor's business. 2. It may be contended, though it is very seldom true, that the contractor in fact has ample funds to meet all just and proper claims against him, but that he genuinely and in good faith disputes the claim in question and is unable to settle it on a fair basis. 3. The company may be surety on the particular contract bond, and as such may be liable for all valid liens, and it may be that the claim in question, for the most part, is undoubtedly a valid lien, so that the issuance of the bond to discharge the lien would not materially increase the liability. 4. Though the surety company may not be liable for liens, yet it may appear that unless the contractor's regular payments are made, he will be unable to complete the contract, so that unless the bond is issued, the contractor will default and throw a loss on the surety. These arguments will be taken up in order, the first two being considered together. It is of course manifest that it is not wise, by needlessly requiring collateral, to drive away a perfectly good client, and it may perhaps be said that where the applicant, a contractor, though he has ample funds to meet all just and valid claims, genuinely and in good faith disputes the claim in question, and is unable to settle it on a fair basis, where the applicant is worth, in net available assets, 15 times the amount of the bond, has not an excessive amount of work on hand, and is a regular and very satisfactory client of the particular company, that company being on the contract bond in question, then it may be the part of wisdom to issue the bond without collateral if it is necessary to do so in order to retain the business of the applicant. However, if it is a fact that the applicant has ample funds, then he should be willing to put up as collateral the amount admitted to be due and owing. To make that requirement is a test of the applicant's sincerity and good faith, and it is advised in all cases where the third argument appears it may be assumed that the applicant is in financial difficulties, and the case would not be one that should even be considered as an underwriting proposition. The case then becomes one for the legal and claim departments of the company, and it is their prerogative, and not that of the underwriters, to say whether or not it is advisable thus to enable the contractor to get money which, in event of his default, would be in the hands of the owner for the benefit of the surety. Likewise, the fourth argument would not be made unless the contractor is in financial straits, and it should never induce an underwriter to issue the bond. It would be little less than foolhardy to issue the bond in that case, but, in any event, it is a matter for the legal and claim departments and not the underwriters. Sec. 153. Bonds for the payment of rent. Bonds which guarantee the payment of rent are very hazardous because, 1. They are clearly credit guarantees, absolutely guaranteeing the payment of money. 2. They usually cover the rent for a term of years, and before the expiration of the lease, a very strong principal may become insolvent, may die, or may jump his lease and dispose of his property. 3. The fact that a bond is required is generally evidence that the lessee is weak financially and cannot be depended upon to pay the rent, although in some cases, the bond is required by law, or in pursuance of a uniform rule of the lessor to require a bond in all cases regardless of the strength of the lessee. As a rule therefore, collateral security to the full amount of the rent should be required, and it may be leased in installments as the rent is paid. Collateral may, with reasonable safety, be waived where the applicant meets the requirements heretofore laid down with reference to credit guarantees in general, where the bond is required by law or in pursuance of a uniform rule of the lessor, and where the bond does not guarantee the payment of rent for a longer period than the year then next ensuing. And in some cases, where the applicant is exceptionally strong and where the bond is required by law, it may be reasonably safe to guarantee the rent for as much as 2 years. But in no event should the payment of rent under a lease for more than 2 years be guaranteed without full collateral. Sec. 154. Bonds to produce bill of lading and pay freight charges. In ordinary course of business, it often happens that bills of lading do not reach the consignee promptly, and it being a rule of the railroads that freight will be delivered only upon the presentation of the bill of lading, it is manifest that unless some satisfactory provision is made, merchants will often be delayed in receiving freight that has actually arrived at the depot. It is also very inconvenient for large merchants to be required to pay every individual freight bill before their drivers will be permitted to remove the freight. In order that their patrons may be accommodated, the railroads generally permit merchants of good standing to remove freight consigned to them promptly upon its arrival, the merchants paying the freight bills weekly or oftener and producing the bills of lading as soon as they arrive or when the freight is paid. But it is the general practice of the railroads to require the merchants to whom they grant this privilege to give bond conditioned for the prompt delivery of all bills of lading and for the prompt payment of all freight charges. Such bonds are of course credit guarantees, and collateral would ordinarily be the rule. But applicants for these bonds are usually concerns of good credit standing who can get credit of this kind without giving collateral. Accordingly, these bonds are generally executed by the companies, without collateral, in all cases where the applicant has a satisfactory credit rating, say $20,000 or better, first grade. But only when adequate provision is made for the protection of the surety. There are two important provisions that should be in every such bond. The first is a provision for cancellation upon notice to the railroad. In discontinuing to grant this accommodation, the railroad is not subjected to any hardship, so it will generally consent to a clause authorizing the surety to cancel upon reasonable notice, say 2 or 3 days. It being understood that the surety shall remain liable for the charges on all freight delivered prior to the expiration of that time. And secondly, there ought to be a provision that in case of the non-payment of the freight charges within 20, or at most 30, days after delivery of the freight, the railroad will notify the surety. Bearing in mind that these bonds are not intended for the purpose of permitting an extension of credit to the principal, but only for his convenience in enabling him to remove freight promptly upon its arrival at the depot, with the understanding that he will promptly pay the charges, it is evident that if the principal does not pay promptly, the surety ought to be notified so that it may take such steps as it may deem necessary for its protection, including especially the exercising of its right to terminate the liability. Generally each railroad has its own printed form of bond, and it is not often possible to get them to make any special exception. But the point for the underwriter to bear in mind is that in cases where the bond does not contain these two provisions, great care should be exercised and they should be executed only for very strong concerns, rated at say $50,000, or where collateral security is obtained. As we have seen, credit guarantees which will continue in force for a long time are particularly hazardous, and as a rule can plus safely be executed only with collateral. Sec. 155. Patent infringement bonds. Our patent laws are such that a man may obtain letters patent on almost any device, unless substantially an exact duplicate has already been filed in the patent office, but he can seldom be sure the device is not in fact an infringement of some previous patent, until it has been so determined by the Supreme Court of the United States. And it is the law that a purchaser of an article which is an infringement of a patent may be compelled to pay to the rightful patentee a proper royalty, which would be approximately the difference between the cost of making the article and the price at which it was sold. It often happens that there are different concerns manufacturing similar articles, each manufacturer claiming to have a patent. Where such an article is sold, the purchaser generally requires the seller to give him a bond with surety to indemnify him against loss on account of suits that may be brought against him on the ground that the article in question is an infringement of a patent. Such bonds are considered hazardous, as they may involve the surety in litigation extending over a period of 3 or 4 years, at the end of which time the principal may be dead or insolvent, and the surety may be called upon for damages equal to the penalty of the bond. If it should be decided that the principal is not in fact the patentee of the article, it is likely to result in his bankruptcy, particularly if the manufacture of this article constitutes a substantial part of his business. It will be seen therefore that, as in all cases of long-term credit guarantees, collateral security to the full amount of the bond should be required. In some cases, it is possible to limit the liability under the bond to any loss sustained during a period of, say, 1 year from the date of the bond, so that if the litigation should not terminate within that time, there would be no liability except for costs and expenses incurred during the year. In that event, the financial condition of the applicant is not so likely to change before the termination of the bond, and where the applicant is a well-established concern, worth exclusive of the patent rights, 10 times the amount of the bond, collateral may perhaps be waived. Where, however, there is no limitation as to time, the concern must indeed be a very strong one to justify the execution of the bond without collateral, as surety companies are seldom justified, without collateral, in writing credit guarantees where the liability may not accrue for 4 or 5 years. A mercantile credit rating, or net worth, of 15 times the amount of the bond is requisite. Sec. 156. Bond to guarantee payment for merchandise to be delivered in the future. Reference has been made to the case where a bond is required to guarantee the future delivery of merchandise. There are also cases where a bond is required to guarantee that a contract for the sale and delivery of merchandise will be carried out, not by the party who has agreed to deliver the goods, but by the party who has agreed to accept them and pay the price. Such contracts generally cover a continuing supply of a certain article, as for example, the output of a mill or factory. If the principal should fail to take the goods and pay the price, the surety would be required to do so. The bond is therefore in a sense, a credit guarantee, but inasmuch as goods are to be received for the money that is to be paid, it is clear that, so long as the goods are worth the price, there will be no loss under the bond. The measure of the surety's liability is therefore the possible difference between the market value of the goods at the time they are to be delivered, and the price provided by the contract. In view of the possibility that the market value of the goods may decline, it is clear that the transaction is a speculative one and that the bond should not be executed unless the principal is sufficiently strong financially to justify a reasonable expectation that he could and would stand the probable loss. If he is not, collateral security for the amount of the probable loss should be secured. If however, the goods are to be delivered and the price paid afterward, so that the surety might be called on to pay the money without getting the goods, then the bond is a credit guarantee, and the surety should be secured against loss in the same way and to the same extent that a bank, which was loaning that amount of money for the term of the bond, would expect to be secured. Sec. 157. Bond of mortgagor to make improvements on mortgaged premises or to satisfy liens. It often happens that a man who owns a piece of land attempts to borrow the money necessary to build a house or make other improvements. If the land is of sufficient value, as compared with the value of the proposed improvements, the money to make the improvements can sometimes be borrowed on mortgage, provided the borrower will give a bond guaranteeing that he will make the proposed improvements within a specified time, to the end that the security for the loan may be adequate. Applications for such bonds are often made to surety companies, and, by executing them, the companies have sustained some severe losses, so they are not looked upon with favor under any conditions. However, there is nothing necessarily vicious about these propositions if the proper tests are applied so as to weed out the undesirable risks. In practice, it is found that the land is rarely of sufficient value to justify a loan of the full amount necessary to erect the proposed improvements, and furthermore, the borrower is generally required to pay a considerable portion of the loan as a bonus to the lender or to the broker who negotiated the loan. The result is that the net amount of the loan is insufficient to make the improvements, and trouble has come to surety companies in cases where the borrower did not have enough money of his own to make up the deficiency, so that the surety company was required, at its own expense, to complete the building. In underwriting these bonds, it is absolutely necessary to be satisfied that the applicant has sufficient money to make the improvement, and that the money will be available for the purpose. The safest way to reach that conclusion is to make the following requirements. 1. That the applicant let a contract for the improvement to a responsible contractor who will enter into the usual written contract with the applicant and his surety. 2. That the contractor give bond with an acceptable corporate surety, payable to the applicant and his surety, as their interests may appear, and conditioned for the completion of the contract on or before the specified time, subject to the proper penalties for delay, and subject to the same conditions, and no others, as those to which the applicant and his surety are subject. 3. That the applicant place with the surety company an amount equal to the contract price and authorize the surety company to pay the money to the contractor in accordance with the terms of the contract. 4. That the contract contain a stipulation that the plans and specifications may not be changed without the consent of the surety company, to the end that a more expensive building may not be substituted. These requirements, if strictly followed, would seem to make the bond in favor of the mortgagee perfectly safe, and they may be considered as the standard conditions upon which these bonds may be written. It often happens, however, that the applicant is himself a builder, and wishes to construct the building, believing he can do it for less than a contractor would charge. Bearing in mind that the troublesome cases have been those in which the borrower himself has attempted to do the work, and where the available money was insufficient, it is clear that, in such cases, great diligence and care must be exercised to ascertain that the money is sufficient. The following requirements will generally make such a proposition as good as the ordinary contract bond. 1. That in honesty, ability, experience and equipment for the particular work, the applicant measure up to the highest standard of efficiency. 2. That the plans and specifications be submitted to a thoroughly competent and practical contractor and builder, who has the interest of the surety company at heart, and that he make an estimate of the cost of the building. 3. That the usual subcontracts be let and that contracts be made for the material for the building. 80. That in reality the only thing to be estimated will be the labor, supervision and incidentals. 4. That all subcontractors and material men, who have not satisfactory credit rating, give bond with corporate surety. 5. That the applicant place with the surety company not only an amount equal to the estimated cost of the building, but also a margin of at least 10%, to cover contingencies. 6. That the usual precautions as to fire and liability insurance be taken. Under these conditions, the risk is about the same as on an ordinary contract bond, the chance of loss being in proportion to the probability that the cost of the building will exceed the estimated cost plus 10%. And it is to be borne in mind that if the 10% margin is not put up, the risk is just that much greater than it would be on a contract bond for the same work, as a contract price always equals the estimated cost plus about 10%. For profit. In some cases, it happens that the applicant, in order to make up a deficiency of cash, will arrange with some of the subcontractors and material men to take his note and wait for their money until the completion of the building, subordinating their claims to that of the mortgagee. In that event, the following requirements, in addition to those outlined above, should be made. 1. That the subcontractors and material men sign written contracts with both the applicant and the surety company, so that if the applicant should default, the contract would be binding in favor of the surety company. 2. In case the principal should default and the subcontractor should fail to comply with his contract, the surety would have to pay someone else to do the work, so that the surety's damage would be the total amount of the subcontract, or the value of the uncompleted portion of it. It is therefore necessary, in each subcontract, to recite the facts and to make provision that in event of default, the full amount of the contract, or the value of the uncompleted portion of it, will be the damage that will be sustained by the surety, and to insert a stipulation for the payment of the damage. 3. That the subcontractors and material men give satisfactory bond for the performance of the contract and for the payment of the stipulated damage in case of default. It is believed that the losses on bonds of this kind have been sustained, not because the bonds, as a class, are necessarily bad, but because the proper tests to weed out the unfit were not applied. It is necessary not only to avoid speculative builders but also the man who is attempting, in good faith perhaps, to do too much with a given amount of money. These propositions require the careful attention of an experienced man, not only in investigating the risk and making proper arrangements for the protection of the surety, but also in handling the details after the bond is executed. This means a considerable expense which should of course be borne by the applicant. The same observations would apply to a lessee, who undertook as one of the conditions of the lease, to erect a building on the leased premises. In some cases the money is not borrowed until after the completion of the building, though before the expiration of the time within which liens may be filed, so that a bond to pay such lien as may be filed is all that is required. In that event, the surety company will have to concern itself only with the question of outstanding bills for labor and material. Investigation ought to be made to determine the amount of the outstanding bills, a statement being obtained from each subcontractor and furnisher of material as to the amount due and a release being obtained from those who are supposed to have been paid. Then the applicant should be required to place, subject to the joint control of the surety, enough money to take care of the outstanding bills, with a margin of at least 10%. For contingencies, the surety may permit this money to be used in payment of such bills as could be converted into valid liens, and the balance should be held until the expiration of the time for filing liens. If no liens have then been filed, the case may be closed and the balance of the money returned to the principal. Sec. 158. Franchise bonds. In earlier times, it was quite a practice for influential citizens to obtain from a city, or other body politic, a franchise giving the right, or perhaps the exclusive right, to erect a lighting plant, a street railway or other public utility, and then hold the franchise for sale to the highest bidder. The result was that the erection of the needed public utility was often delayed. In consequence, it is now generally the practice to require of the grantee of such a franchise a bond condition that he will erect the utility, or cause it to be erected, and have it in operation within a specified time. And in view of the impossibility of ascertaining the damages which the public sustains by a breach of the bond, it has been uniformly held that the entire penalty of the bond is to be forfeited, as liquidated damages, in case of a breach. Such risks are necessarily hazardous because, 1. The grantee of the franchise may not intend to erect the utility himself, but may contemplate a sale of the franchise to a third party, and such sale may not be effected, or if it is, the purchaser may not be able to erect the utility within the specified time. 2. Even if the grantee makes a bona fide effort to erect the utility, he may fail to complete it within the specified time, either from lack of funds or from causes beyond his control. And, 3. If the utility is not completed within the specified time, the whole penalty of the bond will be forfeited as liquidated damages. It would seem therefore to be necessary to require collateral security to the full amount of the bond. However, a fairly good substitute for collateral may be had in some cases by requiring the grantee of the franchise to let a contract for the erection of the utility to a responsible contractor, by requiring the contractor to give bond with corporate surety for the faithful performance of the contract, such bond to be made payable to the joint order of the grantee of the franchise and his surety, and by requiring the grantee to place with the surety an amount of money equal to the contract price, and to authorize the surety to pay it out in accordance with the terms of the contract. In order to make such a proposition safe, it would be necessary to obligate the contractor to complete at or before the time specified in the franchise, and subject him and his surety to the same penalty for failure to complete in time as that to which the grantee of the franchise is subject. It is suggested that this method be followed wherever it is not practicable to get good collateral security. A franchise for a public utility usually contains also a provision requiring the giving of a bond to indemnify the grantor, city or county as the case may be, against any damages that may be caused in the prosecution of the work, reference being made principally to the damages that may be incurred as a result of the tearing up of the streets, roads, etc. This is a credit guarantee, and should be treated accordingly, although it may be possible for the principal to get liability insurance of such a character as to afford ample protection to him and his surety. Sec. 159. License or permit bonds. There are laws in the different states requiring many of those who receive licenses or permits from the state or a county or city to give bond either to indemnify the state, county or city, as the case may be, against loss as a result of the performance of the acts for which the license was granted, or to protect the public against loss. There are literally thousands of different license bonds provided for by law, including bonds of saloon keepers, private bankers, plumbers, users of dynamite, real estate brokers and many others. The liability and risk of the surety are different in the different states, depending upon the terms of the statute, and the strictness with which it is enforced. It is manifestly impossible here to go into the details of the law in each of the states and attempt to indicate the risk of the surety. The most that can be done is to make a few general suggestions, which may perhaps be applied with more or less accuracy in each case. 1. As a rule, these bonds are credit guarantees, in that they guarantee the payment of the damage that may be sustained by the state, county or city or by the public. 2. They are nonetheless credit guarantees because they merely guarantee that the principal will pay over money received. There is no supervision by the state, and the chance of loss depends upon the business success of the principal, as well as upon his honesty. The bonds of private bankers, which are perhaps the most hazardous of all license bonds, are typical examples. 3. While it is not safe as a rule for a surety company to weigh the possibility that the contingency upon which liability depends will happen, yet the law does require bonds in some cases where it has been found that the probability that loss will be sustained by the state, county or city or the public is so remote as to be negligible. 4. There are only a few cases where collateral security is necessary, private bankers, for example, but in most cases the applicant should have financial strength in proportion to the nature of the business in which he is engaged, the penalty of the bond, and the chance that damage will be sustained. 5. Where the particular law, or one substantially like it, has been in force for a considerable time, say 5 years, and no losses have been sustained, it may be well enough to ignore the matter of financial responsibility. However, such cases are rare, for bonds are not required by law unless damage is reasonably possible. In each case the law relating to the duties and liabilities of the licensee must be examined, and should be considered in the light of the terms of the bond and the experience in the particular state. Sec. 160. Refunding bonds. A refunding bond, as its name indicates, is a bond which guarantees that the principal will, upon the happening of a named contingency, pay back a sum of money he has received. It is possible to conceive of any number of circumstances under which such bonds may be required. There may be, for example, two claimants to a fund in the hands of a third person, and such third person may be willing to deliver it to one of them, provided that one will give a bond to return the money in case it be subsequently shown that the fund belonged, in fact, to the other. Or a fiduciary, feeling that there is some doubt about the right of a certain person to receive a distributive share of the estate, may nevertheless be willing to make the distribution to him, provided he will give a bond to return the property in case it be found that he was not entitled to it. Such bonds are nearly always required by the administrator of the estate of a man who is not known to be dead, but whose death has been presumed from a long absence. In practically all of such cases, the bond is a credit guarantee, in that it guarantees the payment of money in case the contingency mentioned in the bond should happen. The risk is of course in proportion to the probability that the contingency will happen, but, as we have seen, it is not the province of a bonding company to weigh this probability, for it must be remembered that in these, as in all other cases of suretyship, the premium is paid merely for the use of the surety's name and credit, and not for taking the risk that the contingency will happen. On bonds of this kind, collateral should be the rule. Sec. 161. Bond for deportation of immigrants. Congress has provided that any alien who shall enter the United States in violation of law and such as shall likely become a public charge from causes existing prior to landing, shall be taken into custody and deported to the country whence he came at any time within 3 years from the date of entry, provided that pending the final disposal of the case of an alien so taken into custody, he may be released under a bond in the penalty of not less than $500, conditioned that such alien shall be produced when required for a hearing in regard to the charge upon which he has been taken into custody, and for deportation if he shall be found to be unlawfully within the United States. Act February 20, 1907, ch. 1134, sec. 20. Such a bond is in effect a bail bond, in that it guarantees that the principal will appear to answer what is in effect a criminal charge, and one for which he may be deported, and in that, the whole penalty of the bond will be forfeited in case of his failure to appear. A surety company cannot of course take the risk that an immigrant, when once admitted to this country, will voluntarily put himself in a position to be deported, and it follows that collateral security to the full amount of the bond should always be required. Sec. 162. Bond of indemnity against immigrant becoming a public charge. Any alien who is liable to be excluded because likely to become a public charge or because of physical disability other than tuberculosis or a loathsome or dangerous contagious disease, may, if otherwise admissible, nevertheless be admitted, in the discretion of the Secretary of Commerce and Labor, upon the giving of a bond conditioned to hold the United States, or any state, territory, county, municipality or district thereof, harmless against such alien becoming a public charge. Act February 20, 1907, c. 1134, sec. 26. If any particular immigrant is, in the opinion of the immigration officers, likely to become a public charge, then manifestly a surety company cannot, without collateral security to the full amount of the bond, guarantee that he will not become a public charge. As we have seen, it is not the business of a surety company to take risks of that sort, the premium being merely for the use of the surety's name and credit. And if the immigrant should become a public charge, the whole penalty of the bond would no doubt be exhausted, so that collateral security to the full amount of the bond should always be required. It would seem that such collateral would have to be retained for quite a long time, if indeed it could ever be released, for it is practically impossible to say with certainty when the possibility that an immigrant will become a public charge is past.